Ladies and gentlemen, hi again. Welcome back after the lunch. I hope it was at least semi delicious. Once again, those who haven't heard my briefing before, my introduction, my name is Andras Kastelic. I'm part of UNIDIR Security and Technology team, and I have a pleasure of moderating this panel today on the role and powers of UN Security Council. I think this is going to be quite an interesting one. As per the convention by now, we have reserved the first 20 minutes for a short briefing by an expert on that particular topic to introduce you to the law, to the doctrine, what states are saying about the law in cyber domain, and so on and so forth. So to provide sort of a framework for the future discussion. That particular future discussion will take 50 minutes, and I'll give the floor to all my speakers, all our speakers on this panel in a second. But after that, allow me to note also that you're going to have a chance to ask questions for the next 20 minutes. 20 minutes for the questions, not only from the room, but also on our Slido platform. The Slido platform, once again, code that you can use for the ones that are following us online. The Slido code that you can use is SCS23, and then you'll be able to pose the questions. I'll see them here, and I'll try to ask in the priority order as indicated on the screen. So quickly, allow me to introduce first our briefer, we called them, is Professor Huang from Wuhan University. He's a professor of international law, and we'll be talking today, as mentioned, about the role and powers of the UN Charter, UN Security Council. And the speaker, starting on my far right, is Ms. Sheila Flynn, Office Director, Acting Director of Global Policy Plans and Negotiations of International Cyberspace Security, Bureau of Cyberspace and Digital Policy, U.S. Department of State. On my right, Ambassador at Large for Security Policy and Cyber of Kingdom of Netherlands, Her Excellency Nathalie Jaarsma. And on my left, Principal State Counsel, Minister of Communications, Knowledge and Technology of Botswana, Ms. Tshenola Sebusang. I guess that was a sign that I pronounced that correctly. So, as I mentioned, I would like the speakers to briefly talk about a national interpretation of the law, or the way they see the particular provisions of the charter that pertain to Security Council in cyberspace. And then we have a couple of other questions, as you've seen with the other panels. So if you don't mind, Sheila, I'd like to start with you. Would you like to? Oh, no. Okay, apologies. Your faces were very telling. I'm very sorry, President Huang. I apologize for that. Would you like to give us a presentation for 20 minutes about the law, and then we can continue with speakers? Thank you.
Okay. Thank you, Andres. Good afternoon, Your Excellencies, dear participants. It's a great honor for me to be invited to make this briefing before such a distinguished audience. And I thank the organizers for giving me this privilege. Next slide, please. To discuss the role and powers of the UN Security Council in the ICT domain, let's begin with such a scenario. The critical infrastructure of State A, its power grid, water supply, transportation systems, was targeted by a sophisticated cyber attack, possibly launched by State B, which caused widespread chaos and disruption, leading to social unrest and economic instability. State A vowed to retaliate with military force, which may well escalate into a full-blown war. I think you will all agree that this scenario is not something far away from our daily life. In today's interconnected world, cyber threats are becoming increasingly frequent and sophisticated. which not only affect individuals and organizations, but can also have serious implications for international peace and security. Then the question is, what can and should the Security Council do to deal with situations like this? Next slide, please. Before getting into the details, I think several general observations can be made, which hopefully will allow us to have a better view of the larger landscape. Number one, compared to many other issues related to ICT security, including those discussed in the other three panels of this conference, the issue of role and powers of the Security Council has received much less attention. Number two, compared to the UN General Assembly, which among others have convened 6 sessions of the UNGGE and 2 sessions of the OEWG. In the past 2 decades, through its first committee, the role and powers of the Security Council has been much less noticed, despite the primary responsibility to maintain international peace and security entrusted with the Security Council. Number three, compared to the role and powers of the Security Council in other fields, where it often has to face the criticism of exceeding its authorities, the Security Council has done much less in ICT security, despite the increasing global concern over this issue. Next slide, please. Pursuant to the instructions of the organizers, my responsibility is to facilitate the panel dialogue by outlining the status quo, and in particular, the relevant lex letter or the law as it is. I will first discuss the role and the powers of the Security Council in the general context, as well as its extension to the ICT domain. Then try to summarize the multilateral discussions on the role and powers of the Security Council in the context of international ICT security. The next part will be an overview of state practice and opinion jurists regarding this topic. In the end, I will also try to draw some conclusions. Next slide, please. In order to allow my briefing to be better understood, I have organized my analysis in the first part in the form of Q&A. And this is my first question. What are the intended purposes of having the United Nations? I have no doubt that you all know more on this than I do. The answer is rather clear. Well, there are other purposes. The overriding purpose of the United Nations is to fulfill the task of safeguarding peace and security on behalf and in the interest of all countries around the world. This has been made very clear in Article 1 of the UN Charter. And as you are all familiar with this, I don't think there is a need for me to read out this article, but it should be stressed here that Next slide, please. That the system inaugurated in 1945 was rather ambitious and revolutionary indeed, with two core ideas. On the one hand, states should endeavor to solve their disputes peacefully and never use force under Article 2.3 and 2.4, subject to the exception of self-defense. And on the other hand, the UN would act as a world policing and enforcement agency. Moving to the second question, what is the role of the Security Council in this new system after the Second World War? Again, I'm sure you know more than I do. The Security Council is entrusted with primary responsibility for the maintenance of international peace and security. Under Article 24 of the Charter, and the next slide. In order to fulfill this responsibility, the Security Council has been vested with broad powers, especially the peaceful settlement of disputes under Chapter 6 of the Charter and the adoption of enforcement measures under Chapter 7. So for example, under Article 34 of the Charter, the Security Council may investigate any dispute or any situation which might lead to international friction or give rise to disputes in order to determine whether the continuance of the dispute or situation is likely to endanger the maintenance of international peace and security. I'm sure the other powers of the Security Council under Chapter 6 will be discussed in the next panel. And then, if the Security Council determines the existence of a threat to or a breach of the peace or act of aggression under Article 39, it may decide upon measures not involving the use of armed force under Article 41, or take armed actions against the aggressor or the state threatening the peace under Article 42. So very importantly, the Article 39 determination serves as the gateway to Chapter 7 and triggers the measures in that chapter. Of the three expressions in Article 39, namely threat to the peace, breach of the peace, and act of aggression, the first is by far the most often used in the practice of the Security Council and had been given an extended meaning over time from classic interstate armed conflict to internal conflict, international terrorism, proliferation of weapons of massive destruction, violation of human rights law, protection of civilians, and violation of international humanitarian law, piracy, organized crime, health crisis, the effect of climate change to conflict, etc. Next slide. Then the next question to be asked is, in the ICT domain, what's the performance of the Security Council in exercising those powers to address cyber threats that pose a risk to international peace and security? The answer appears to be not very impressive. It has hardly taken any formal action in response to cyber attacks. No formal investigation under Article 34, and no formal determination under Article 39, let alone actions under Article 41 and 42. You can see there is a sharp contrast with its performance in other fields. Instead, so far, the Security Council focused on discussing this issue of cybersecurity and its potential threat to international peace and security, a point we will come back a bit later. So, for example, in 2017, the UN Security Council passed a resolution that expressed concern over the use of the internet to incite others to commit terrorist acts, and underlines the need to prevent terrorists from exploiting technology to incite support for terrorist acts. Next slide, please. With this in mind, my fourth question is, can a cyber incident constitute a threat to international peace and security, breach of the peace, or act of aggression at all? My answer is, while this determination would be a complicated and evolving issue, as can be seen from the past practice of the Security Council in the general context, it would be safe to conclude that major cyber attacks, especially those targeting critical infrastructure and causing major physical damage and or loss of life, could well constitute a threat to the peace, to say the least. This has also been confirmed by various GGE reports. Of course, the difficulty of attributing cyber attacks to specific actors may well create challenges for the Security Council's enforcement power. Next slide, please. My second part aims to summarize multilateral discussions on the role and powers of the Security Council in the context of international ICT security. As was mentioned earlier, this issue has been discussed in various multilateral forums, including area formula meetings of the Security Council, the Security Council's open debate, the UNGG, and OEWG. First is the area formula meetings. In recent years, several area formula meetings have been organized, which provide a forum for informal and closed-door discussions among Security Council members, non-members, and experts to foster greater understanding of the complex and evolving nature of cybersecurity threat and the potential ways in which the Security Council could play a role in responding to this threat. The meetings focused on, for example, identifying challenges, analyzing the potential role and powers of the Security Council, examining the current legal and normative frameworks for addressing cyber threats, etc. Then Second is the Security Council's high-level open debate. The Security Council convened one high-level open debate on cybersecurity in June 2021 to promote better understanding among states of the risks and the implications of malicious cyber activities. Members generally agreed that implementing existing norms of responsible state behavior in cyberspace and the confidence and the capacity building measures help minimize mistrust between member states, etc. So, third, the UNGG and the OEWG, we can see almost all previous GGE and OEWG reports touched upon the issue, this issue. For example, the GGE's report of 2010, 13, and 15 confirmed that the ICT may be used to threaten international peace and security, and that the Security Council should play a greater role in addressing cyber threat and maintaining international peace and security. Also, the importance of the Security Council for the peaceful settlement of disputes and the application of relevant charter provisions in cyberspace were indirectly recognized in the 2021 GG report, as well as the OEWG report indirectly. But I don't have time to go into the details. Then, next slide, my third part is an overview of state practice and opinion juries. Until now, my count is around 25 states have delivered their national positions on the application of international law in cyberspace through different ways. And this statement can be considered as representing state practice and opinion juries, which has the potential to shape future international customary rules in cyberspace. Yet it should be admitted that even among those limited national positions, the role and powers of the Security Council in the ICT domain was not a prominent issue. 13 out of the around 25 states directly mentioned the role and or functions of the Security Council, and their views, by and large, fell into three categories listed on the slide. No doubt, these national views, as well as similar views from other states in the future, should be welcomed. However, as far as existing national views are concerned, most of them simply stated the very basics in one or two short sentences, and more in-depth elaboration on the role and powers of the Security Council in the ICT domain will be needed. Next slide, please. Now, my final preliminary conclusions. First, the Security Council has a key role to play in maintaining international peace and security in the digital age. Its mandate under the Charter allows it to address threats to ICT security that have the potential to destabilize global peace and security. It also has the power to investigate, determine, and take action against cyber attacks which pose a risk to international peace and security. Second, so far, the Security Council has not fully explored its potential in the ICT domain. Just recall the three much less I have described at the beginning of my briefing. Consider the serious threat posed by cyber attacks. This reality is indeed unfortunate. And the increasing collectivization and polarization among states on many security issues in recent years would likely make any major change very difficult. Having said all that, in the end, it's in the interest of all countries to prioritize the multilateral approach represented by the UN and in particular the Security Council. Just think about the heated debate over unilateral exercise of the right to self-defense in cyberspace with little consideration about the role and powers of the Security Council. I'm sure the dialogue today will serve as a useful step forward to build consensus on how to revitalize the Security Council and allow it to effectively fulfill its mandate to maintain international peace and the Security Council in the ICT domain. With this, I finish my briefing, and I thank you for your attention.
Thank you very much, Professor Huang. I think this was a really nice, concise, and very well-organized presentation. I really like the questions and answers approach. I wish I could come up with that myself for my past briefing. Thank you also for the kind words about the purpose of this conference. I hope we can deliver. With that, now is the time to hear from member states. I apologize again for the blunder. And with this, I'd first like to give the floor, as mentioned, to Ms. Sheila Flynn. And specifically, I'd like to, I think we'd all like to hear about the interpretation of your government, of the relevant charter provisions, but also if you would like to talk briefly a bit more about the peacekeeping powers of the Security Council, particularly so that was my question, but it goes in line with a question that we actually got from the audience already. Is there a role for cyber peacekeeping force? And is this something that you think Security Council can indeed suggest? So with that, please. Thank you.
Thank you, and greetings, colleagues. Thank you, Professor, also for your presentation. That was very helpful for our conversation. As the professor acknowledged, the UN Security Council has primary responsibility for the maintenance of international peace and security. Our work on cyber issues in the first committee and discussions in the Council have demonstrated that member states believe that cyber incidents could undermine international peace and security. For instance, issues of international peace and security can be implicated when one country causes severe disruption to another country's infrastructure through cyber or other means. Thus far, member states have focused multilateral cyber discussions within the UN system to discussions within the First Committee, where we have had remarkable success establishing a framework for responsible state behavior in cyberspace. In recent years, however, member states have brought certain cyber issues to the Security Council's attention, suggesting that we all need to develop our positions on the appropriate roles for the Council in dealing with these cyber matters. I thought it might be helpful to provide a bit more detail on how cyber issues have been raised recently in the Council. In February 2020, the permanent representative of Georgia wrote to the Security Council to highlight Georgia's conclusion that Russia was responsible for a large-scale cyber attack that disrupted Georgian government and private sector networks. In response, in March 2020, the United States, United Kingdom, and Estonia raised the cyber attack on Georgia during a Council meeting and released a joint statement concluding that Russia conducted these cyber attacks to sow discord and disrupt the lives of ordinary Georgian people. In May 2020, the Council held an ARIA formula meeting on cyber stability and responsible state behavior in cyberspace. The U.S. representative outlined the development of and global support for the framework of responsible state behavior. The United States also highlighted that cyber threats to healthcare systems, such as ransomware, were of particular concern as the world dealt with the COVID pandemic. The U.S. highlighted one of the framework's key commitments that states should refrain in peacetime from cyber activities that intentionally damage critical infrastructure, including healthcare and public health services. In August 2020, the Council held an ARIA formula meeting on cyber attacks against critical infrastructure. In its remarks, the U.S. representative drew attention to the increasing cyber risks to critical infrastructure, noting that irresponsible states that do not abide by the framework will be held accountable. The U.S. also highlighted the decades' worth of work the UN has undertaken to help states protect critical infrastructure from cyber threats, including best practices for domestic cyber protection and the focus on critical infrastructure within that framework. In June 2021, the Security Council held an open debate on cybersecurity. At the time, the United States had just experienced a series of high-profile ransomware incidents targeting our critical infrastructure. The U.S. ambassador highlighted the growing risks cybercrime posed to critical infrastructure, noting President Biden's statement that countries need to take action against criminals who conduct ransomware activities on their territory. We highlighted again that state-to-state cooperation to deal with cybercrime actors is essential. Finally, in May 2022, the United States co-sponsored a Security Council meeting on the use of digital technologies in maintaining international peace and security, which included some discussion on cybersecurity risks and the need for states to adhere to the framework. At the same meeting, UN officials presented on how digital technologies are being deployed in ongoing UN peacebuilding efforts. In addition, in recent years, the 1718 Committee panel of experts on DPRK matters has drawn attention to DPRK's use of cyber capabilities to steal funds and information in support of its unlawful WMD and ballistic missile programs, demonstrating the need for the Council to be aware of how cyber tools can be used to facilitate other activities of concern. Security Council subsidiary bodies can have an important role in investigating alleged malicious cyber activities as they relate to their mandates. The DPRK panel of experts reports leverage private sector reporting, open source information, and a variety of inputs from state and non-state actors to highlight overwhelming evidence that DPRK cyber actors use cyber tools to support the country's prohibited programs, including WMD. My understanding is that the POE does not have an independent capability to determine attribution. Instead, they can highlight and assess attribution claims and pull together multiple sources. Their reports are a valuable contribution in this context and make it easier for states to develop their own assessments of the situation. By bringing these issues to the attention of the Council, states have already demonstrated an understanding that certain cybersecurity concerns do fall under the Council's scope and may rise to the level of threatening international peace and security. Given the Council's responsibility, it does need to pay attention to the most serious, disruptive, destructive, or otherwise destabilizing cyber incidents. If the Council and member states stand strongly against such actions, it sends a powerful signal to the international community and can shape future behavior. At the same time, not all cyber incidents would rise to the level of the Security Council. Nevertheless, the Council can use the power of its platform to highlight a range of positive actions states can take to improve international cyber stability, such as implementing domestic best practices or participating in cyber CBMs programs that support state-to-state cyber incident response. In this context, it is fair to recognize that Security Council sanctions could be on the table in response to those severe cyber incidents or activities that could impact or threaten international peace and security. But given that this is a relatively new area of interest for the Council, states will have to think carefully about how to approach the relatively new issue within the Council. Regarding the issue of the Council's role in investigating non-state cyber threats, several aspects need to be taken into account. First, we need to distinguish between ordinary cybercrime and those cyber incidents that rise to the level of an international security concern. In general, states have the most advanced cyber capabilities, which, when used irresponsibly, are destabilizing and may, in some instances, threaten international peace and security. Second, as mentioned earlier, it is our expectation that states, when notified, should take action to address the activities of cybercriminals operating from their territory. We are concerned that some states are able but unwilling to take such action. For those states that are willing but unable, other states should provide support where possible. Now that states have shown a willingness to raise certain cyber issues to the Council, it is right for all of us to consider how cybersecurity matters should fit within the work of the Council and how its powers should be leveraged to improve international peace and stability in cyberspace. Regarding the specific proposal for, or not proposal, but concept of cyber peacekeeping forces, assisting the victim of a destabilizing cyber incident has some unique characteristics, including the ability to provide virtual assistance, robust private sector expertise, and the need for technical capacity. Also, cyber incidents can occur with little to no warning, and often it can be unclear for some time whether a disruptive incident was caused by a cyber actor, user error, or some other technical glitch. Notions of cyber peacekeeping forces are interesting and maybe a topic of academic interest, perhaps, but from my perspective, it has not been an active area of multilateral discussion between states. Although this overall question of Security Council role in cyber matters is an emerging area of consideration, I think it's fair to say that the cyber diplomatic community is at the beginning stages of considering how to leverage the power of the Council to address cyber issues of international security concern. Given that, I want to thank the organizers for drawing attention to this question of its role in cyber matters. It's a topic worthy of much more discussion going forward. Thank you.
Thank you, Ms. Lin, again, also for the encouraging words, not only for your initial intervention. I have a couple of questions, but I'd first like to go through all the speakers, if you don't mind. So with that, Ambassador Jasma, if you'd like to explain also what is your position or the position of your government on this particular body of law as discussed. And also, perhaps if we could, so Sheila at one point mentioned that not all cyber operations would actually arise to the level that would warrant a discussion by Security Council. So what do you think, what kind of parameters of cyber operation would actually warrant for Security Council to actually step in and discuss an operation as such? Thank you.
Yeah, thank you, Andras, and good afternoon, colleagues. First of all, let me thank UNIDIR for organizing this thought-provoking conference today. It feels a bit like I'm back in university for a day and I'm really impressed by the panels that we've already had. And for me personally, one of the great joys of being a cyber ambassador is that I get to think and work on the intersection between topics like peace and security, law and technology. I firmly believe having the discussions we're having here today are imperative for us to come closer as international community in understanding exactly how the rules of international law apply in cyberspace. And what better place to start than the Charter? It's the backbone of our rules-based international order, and we have collectively and consistently acknowledged it is applicable to cyberspace. Given the importance of this topic, which is also one of the subtopics of international law as reflected in the Open-Ended Working Group's annual progress report of 2022, we are happy to discuss it ahead of our formal discussions on the topic under the agenda item on international law next week. I was delighted to be invited to this particular panel dedicated to the role and powers of the UN Security Council. And think about it. The global cyber threat continues to grow, both in scale and impact. And this threat increasingly rises to the level of international peace and security matters. So it makes sense to think about the role of the Security Council. And as my US colleague highlighted, we can see that the Security Council has in fact addressed cyber at several occasions in recent years already. I think our work in the first committee lays an excellent foundation for considerations on cybersecurity in the Security Council. In previous OEWG and GGE consensus reports, states have reaffirmed that international law, and in particular the UN Charter, is applicable to cyberspace and essential to maintaining peace and stability in cyberspace. And as mentioned by the previous two speakers, responsible state behavior in the cyber context was already part of ARIA meetings and the work of the UN Security Council in 2020. And the first committee continues to have a key role in further developing common understanding of the normative framework, including the UN Charter, which I would consider to be a starting point in thinking about the role of the Security Council. Before I delve into the substance and the questions, let me start with a caveat that I'm not a lawyer and that I will be sharing my own reflections in a personal capacity. The Netherlands has published its position on how international law applies to cyberspace in 2019, from which I will also draw. And it's a great privilege to have a legal advisor on our team here this week, Anne, although I might get some angry looks from her as I start to talk about law. Let me turn to the questions. And that is what parameters of a cyber operation should be considered by the UN Security Council in determining whether an ICT constitutes a threat to the peace, breach of the peace, or an act of aggression. It is clear that the drafters of the UN Charter envisaged that the UN Security Council has the primary responsibility for international peace and security. As is stipulated in the UN Charter, it is the Security Council that has the authority, first of all, to determine the existence of any threat to the peace, breach of the peace, or act of aggression. So, a first important point to make here is that even when we are talking about defining legal terms here, determining the existence of a threat to the peace, breach of the peace, or act of aggression is firstly a decision of the UN Security Council. At the same time, we believe these discussions we are having today contribute to the development of a common understanding of the normative framework, and in particular, the UN Charter, which will inform and guide future work of the UN Security Council on cyber. Let me now turn to the concepts of threat to the peace, breach of the peace, and act of aggression in the cyber domain, and how they relate to the thresholds of the use of force and armed attack. I will start with considering them from a legal perspective. An ICT act can constitute a threat to the peace or a breach of the peace. Let me start with threat to the peace. A threat to the peace may include activities that are likely to cause instability on a large scale. It's important to note that a threat to the peace does not have to involve use of force or an armed attack. Therefore, the Security Council is authorized to take action even before the scale and impact of a cyber operation has risen to the level of use of force. Of course, the nature and context of each case will be crucial, but important parameters, in addition to scale and effects, which I already mentioned, are the type of systems the ICT operation aimed to affect, and the extent to which it is clear from which actor these ICT activities originate. But cyber operations that risk undermining the international order and stability may thus trigger the mandate of the Security Council. Let me now turn to breach of the peace. In contrast with threat to the peace, a breach of the peace would in any event require the element of the use of force. It is the position of the Netherlands that cyber operations involving armed force or causing severe financial or economic damage could qualify as use of force. It is also the Netherlands' position that cyber operations could qualify as the use of force when the scale and effects are comparable to the use of force in the conventional world. In other words, the scale and effects of a cyber operations are decisive, not the manner in which these effects are accomplished. Whether the threshold of use of force is met needs to be assessed for every particular cyber operation on a case-by-case basis. As stated in its position on how international law applies to cyberspace, the Netherlands is of the view that a number of factors could be taken into account in the assessment, such as the severity of the consequences of a cyber operation, its impact, and the question of whether the operation has a military character and is deployed by a state. Let me finally address the act of aggression. According to UNGA Resolution 3314, an act of aggression is the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state. The threshold for acts of aggression is considered to be high and requires an aggressor state which has the intent to use grave forms of armed force. The current definition of aggression under UNGA Resolution 3314 is relatively broad and provides only a non-exhaustive list of examples. The question whether certain state conduct using ICTs constitutes an act of aggression needs to be assessed by the UN Security Council. Of course, this assessment will benefit from common understandings developed on how international law applies to cyberspace, and in particular the UN Charter. And today's discussions hopefully further contributes to that. Let me lastly discuss the examples of acts of aggression in the UNGA resolution on the definition of aggression. In theory, if a cyber operation amounts to any of the acts already included in the UNGA Resolution 3314, these cyber operations may indeed qualify as an act of aggression, may qualify. Beyond that, Article 4 of UNGA Resolution 3314 notes that the acts listed in the resolution as constituting aggression are not exhaustive, and other acts may also constitute aggression. It may be imaginable that the effects of a cyber incident could equate to the type of effect of acts that are referred to in the resolution. Looking at the non-exhaustive list of examples in the resolution, I want to highlight one that I could imagine could also take place in cyberspace. For example, cyber operations that lead to irreversible damage of the air fleet, including the air force of a state, would constitute an act of aggression. An additional question in this context is if, in case the effects of cyber operations only manifest themselves in the cyber domain, whether these cyber operations could qualify as acts of aggression. It's a question. Personally, I would say this threshold is very high when we think about the types of effects we see coming from cyber incidents. But with the rapid advances in technology and cyber, it is nonetheless important for states to think this through. Theoretically, at least, the definition of aggression seems sufficiently broad and flexible to accommodate the types of effects that cyber operations can inflict in this context. To conclude, I hope that this contribution is only the start of focused discussions on our common understandings of these legal thresholds in the context of cyber, which will hopefully continue in the open-ended working group. Thank you.
Thank you very much, Ambassador Jasma. That was very, very comprehensive. I appreciate that. With that, if you don't mind, Ms. General, I'd like to turn to you specifically, not only as a standard practice already by now, not only the position of your government towards the specific provisions in the United Nations Charter related to the Security Council, roles and powers, but also some certain things perhaps maybe that relate to threat to peace, breach of peace, and act of aggression, something similar that Ambassador already attempted beforehand. If you'd like to elaborate on that, that would be highly appreciated. Thank you.
Thank you, Andy, and good afternoon, colleagues. First, to answer the first question on Botswana's position on the applicability of international law in cyberspace, Andy, I wish to note that Botswana currently does not have a defined or comprehensive position on the applicability of international law in cyberspace, except for having reaffirmed in our statements before the OEWG that international law, including that of the UN Charter, applies to cyberspace. In terms of how it applies to cyberspace, it's a matter under discussion, and once we have undergone consultations with the relevant stakeholders, Botswana will share a position on that. When answering your question on the non-forcible measures that the Security Council can use, Article 41 of the UN Charter bestows upon the Security Council the power to decide on measures to use that do not involve the use of force, and it gives a non-exhaustive list of measures, which include a complete or partial interruption of economic relations. This could talk to things such as the sanctions, economic sanctions, arms embargoes, your trade embargoes, your asset freezes, and travel bans. And I should stress that trade in humanitarian goods is not subject to sanctions under international humanitarian law, and that as time goes, there are newer types of non-forcible measures that the Security Council can use. They have recently used establishing ad hoc tribunals and also referring issues to the ICC. I think that'll be that. Thank you, Andy.
Thank you very much. I understand I did not want to put you in a tough spot. I understand that perhaps if official position is not fully elaborated, but nonetheless, I find these discussions quite interesting. So I thought, if you don't mind me continuing now, we talked about, I asked about non-forcible actions that are at the disposal of the Security Council. But what is your either or position or your opinion on the forcible measures? Could these involve some sort of cyber means as well? So forcible measures, obviously, I'm talking about forcible measures approved by the Security Council.
Under Article 42 of the Charter, it is provided that should the Security Council measures that have been provided for under Article 41 prove to be inadequate, the Council may take action by air, sea, or land forces as may be necessary. The Security Council has the power to authorize a state to act in self-defense to an armed attack under Article 51. Article 51 basically gives states the right to act in self-defense in case of an armed attack. An armed attack in this instance is an attack that reaches the threshold of the use of force as provided for by Article 2.4 of the Charter. And consideration is made to the scale and effect of the attack, as Natalie has indicated earlier on. And also, it should be considered whether the effects of the attack compared to a kinetic attack, which involves the loss of life, injury, and substantial damage to property. I believe that a cyber attack that is comparable to a kinetic attack and has an effect in loss of life, it causes injury and also causes substantial damage, should constitute an armed attack. And in my opinion, I believe that the response to a malicious cyber attack shouldn't necessarily be limited to air, land, and sea, because I don't believe that is the intention of the Charter. I believe that once the right of self-defense is triggered, a state that is under attack can basically resort to any or all necessary and proportionate measures to end the attack, and that the use of force should not necessarily be disproportionate or should be excessive, and that it should be necessary to end the attack or to prevent it. Thank you, Andy.
Thank you. Sort of reminiscent of the past, of the previous panel. I appreciate that. Elaborating. Thank you very much. There are a couple of online questions already. I'll try to interpret them to the best of my ability. I see no questions from the room. If you don't mind, please do indicate that you would like to speak, and I'll try to give the floor as soon as possible. But in absence of these, I'll try to go and I'll try to turn to the online questions. Now there are no questions that are not really directed to any of you, but nonetheless, your take would be appreciated. So one of our questions says, cyber attacks could lead to the World War III. So what is the capacity of the United Nations Security Council in preventing cyber conflicts regarding issues of misattribution? Particularly, misattribution seems to be a hot topic. It's quite interesting, even though we're talking about a charter today, we keep on coming to the attribution through both of the past panels. And now, unfortunately, that was not what we envisioned, but I'm glad that we're at least dipping our toes in that debate as well. Would you like to start, or would whoever, please, the courageous ones, please.
Well,
Thank you.
I think the current acquis, our normative framework, is already very clear when it talks about attribution, that all states have a responsibility to take all information into account when they are considering a cyber attack and if they want to attribute. And so in our view, it is crucial that states have procedures in place and are transparent about these procedures in the way they have made sure that they have checks and balances in their system when they are trying to attribute. This is, of course, I realize that there are different views among the UN member states, but this is very much a topic I think we need to build better understanding on. But the previous GGE report is already giving quite a bit of understanding there.
Tend to concur with Ambassador Yarsman's statement there on the guidance that the GGE and other products have given on notes of caution regarding attribution and the complexities of cyber attribution. Generally speaking, the United States and many other states view cyber attribution assessments as a national competency, and they often require the use of sensitive sources and technical capacity. Realistically, it's difficult to envision a scenario where a body of the Security Council would have some sort of independent capacity to attribute cyber incidents. That said, we have long recognized as a matter of policy that states may choose to disclose specific evidence used in making cyber attribution decisions for a range of reasons, including to draw the attention of other states to the problematic behavior. I would also point to my earlier remarks about the panel of experts reports and the value they can play and similar reports can play in compiling evidence to demonstrate not just one source, but a wide body of sources that help member states understand conclusions such as that. So.
Yeah, that makes sense. But my question was maybe my question should be actually probably more targeted. What do you think of the potential of area formula meetings to contribute, I suppose, to the norms that you mentioned, to the normative framework, and perhaps by virtue of that, so consider all contextually relevant information when attributing and so on and so forth. Would that perhaps contribute to greater capacity and greater knowledge by the states, and by virtue of that, maybe refraining from misattributing some certain cyber operations or are there any other mechanisms of the the Security Council that could play into that, and what would these actions by the Security Council be in this regard when it comes to the misattribution question? Nope. Okay. Very well. Indeed. Yep. Okay. I'm afraid no more questions online, at least not the ones that are. Okay. No, there's one question. I'm sorry, it hasn't been approved yet. So one question that came from online once again. I see no raised hands, no requests from the room. But one question I thought it was quite important was, how can we improve or strengthen the link between what's being discussed on at the OEWG and the Security Council? The links, so the question goes, is investigating the links between the Security Council and OEWG, how to strengthen the link, whatever that's supposed to mean. I see often in these debates is the necessity for the different processes or different areas of UN to work more in harmony. Very often I hear the word silos. So I'm assuming that this is something that the question might be investigating. She said pass it to them first, so if you don't mind.
Sure, and I think I covered this a bit in my earlier remarks in that the meetings that have taken place within the Security Council already, the ARIA formulas and others, have spent a lot of time looking at what's already be underway within the UN, in particular the conclusions of the GGE and OEWG reports, and have drawn perhaps political and high-level attention to those reports that hadn't been done in other ways. So in this context, I think it's been quite valuable and quite synergistic because we're using the Security Council and its platform to highlight and promote what's being discussed and already affirmed in the first committee.
Okay, thank you for that. Thanks for stepping up. There's another question that is more or less. You want to try? To the previous one?
No, I would actually agree with
Okay, very well. Very well. So the next question that came online, once again, still no speakers from the room, but nonetheless, there's a lot of discussions, I suppose, on the reform of the Security Council. Are there specific talks, or amongst these discussions, on the role of powers of Security Council in terms of cyber crises? Now that probably requires some knowledge of these discussions of the reform. So if anyone is familiar with that. No. Very well. I think, no? Okay. I think that would be then it. Chris, is this a hand up? Were you scratching your head or? Yep, I think you got it for a second there.
No, did I?
Yep.
Okay, good. Well, just to interject some real politic in this too, and this is not unique to cyber certainly, but one challenge of the Security Council getting involved in this or any other dispute is if, which is often the case in cyberspace, that if a state actor is involved and that state actor is on the Security Council and has veto power. So how do you deal with that? Is there, it's a larger question, certainly. It goes to your reform issue in some ways. But is there things the Security Council can do, even if ultimately one of the members vetoes further action?
Thanks, Chris. Indeed, a bit of a wider question, I suppose. Apologies. Would anyone like to tackle that? Nope. Okay. Okay. I understand. I got the. Oh yes, of course, Professor Huang. Please do.
As I tried to mention earlier, the effective operation of the Security Council in particular relying on the cooperation, the collective action among the states, especially the permanent members, and the current political climate is that any cooperation among those permanent members would be difficult. So we have to, but in the longer run, I'm sure that is in the interest of no country. So in the end, it depends on how the members of the Security Council, in particular, the permanent members, can build mutual trust in this area. And also to the previous question regarding the relationship between the OEWG and the Security Council, I agree. Some panelists also mentioned that the report of the OEWG, the discussions in the OEWG already provide useful support for the operation of the Security Council, like the confirmation that major cyber threat may constitute a threat to international peace and security. On the other hand, there is a possibility, but also a difficult one, to make use of the Security Council to reinforce the discussion and the negotiation in the OEWG. That's the possibility for the Security Council to make use of Article 25 of the UN Charter. That is, the Security Council can make binding decisions or exercise some kind of legislative power. That is an efficient way to fill the gap of the rules. But again, the problem is how can the permanent members reach agreement? Because that's all the basis, the very basis that the Security Council can move forward. So, but this could be considered, I think, the potential of the Security Council.
Please, yes.
I just wanted to react to a word that our colleague from Botswana used that I really very much appreciated, and that's the comment about what was the intention of the Charter. Of course, the Charter was written before we had cyber. Then it also comes down to sort of the question about working in silos. I think the work that we're doing in First Committee in trying to build a common understanding on international law is really important to actually inform the Security Council exactly for this particular reason, that cyber was not part of the Charter for very logical reasons. So what was exactly the intent? And well, it's really, we need to have those conversations in First Committee. Thank you.
Thanks for the additional clarification. Anyone else? I see no hands again in the room. I believe with this we exhausted the list of questions that came online as well as the ones in the room. Once again, I thank you all for your participation and for all the interventions as well as answers and some food for thought for future discussions. With this, I kindly invite you to slowly make your way towards the coffee break once again, and then we'll return at 4:30 for another session, this time on peaceful settlement of disputes and specific provisions of the Charter. Thank you again for attending, and see you in good half an hour, 45 minutes.